But hello, welcome. If you have not met me, I am Chandler Fiffick. I'm the director of the Evolve Technology Program at the Youngstown Business Incubator. Our program manager, Rory Kale, is also here. Rory, give a wave. And welcome to Crash Course in IP. We're very excited to have you, very excited to have a very special host today, Camron Bagheri of Amin, Turocy, and Watson. But before I get into intros, I would like to give you all a high-level overview of the Youngstown Business Incubator in case you are not familiar. We are a 5-building campus, soon to be 6, in downtown Youngstown, Ohio. We have 4 programs within our economic development organization, which YBI is first and foremost. The program hosting this Lunch and Learn, YBI Evolve, is the Technology Incubation Program. We work with technology-based startups located all throughout Northern Ohio. Our primary focus is on advanced manufacturing startups. We are the designated Center of Excellence for Advanced Manufacturing, Incubation, and Acceleration in Ohio. And with the Innovation Hub for Aerospace and Defense coming aboard on our campus, it is very, very fitting. We started with software, and because of that, we are not letting go of our software roots. We're very good at helping those companies scale and thrive. So we do have a secondary cohort of software and health tech companies, as well as a third cohort now with international YBI companies, and we have quite a few of those companies within our portfolio. We do not take equity in our startups, and we do not charge for our services. If you are accepted into our portfolio, you have access to all of our resources, our entrepreneurs and residents. We have 9 right now that serve as the mentors to our companies. We have some internal grants depending on your company's, I guess I should say, trajectory and where you are at any given time that you can apply for. Camron is actually one of our resources. Our companies that contract with his firm do get a YBI Portco discount. So thank you, Camron, for that. And that's probably enough for now, because as Rory knows, I could go on and on and on. But if you do have questions about YBI Evolve, feel free to reach out. Our application is online, and we're happy to tell you more. So let's get to it. I know we have a very interesting webinar today. Camron, like I said, is from Amin, Turocy, and Watson. He is a senior associate and patent attorney. Camron is a Youngstown State University graduate from Youngstown originally. We're hoping to get him back here soon. He graduated with a BA in mechanical engineering, then went on to get his law degree, I think it's UPenn Law. So very accomplished individual. I'm not going to go into all the things that he knows because I will bungle it. I'll let him do that. So feel free to put a question in the chat. We're going to save a few minutes at the end for a Q&A. But if you do put a question in chat, we will ask it on the spot if you have something about exact to what he is speaking to. So with all that said, I am happy and thrilled to turn it over to Camron.
All right. Well, thank you so much, Chandler, for that lovely introduction. And thank you, everybody, for taking the time to come to this talk today. I know you all have busy schedules, so I really appreciate it. Yeah, as this title slide says, my goal today is to give you all a high-level and hopefully exciting or action-packed introduction into the wonderful world of intellectual property law. So before I begin, I have to start with the obligatory disclaimer. Just anything in my slides today for educational purposes only. Please keep that in mind. But away we go. So before I actually get into the details of IP law, I thought it would be interesting to first explore a little bit about why we have IP law in the first place. What do you guys think? Most people when they're asked that question, will probably come up with something like a fruit of your labor rationale. They'll say that if they make something, if they pour their blood, sweat, and tears into it, it should be theirs. It's a fairness thing. Some countries use that as their justification, but not the US. No, we use an economic incentive rationale. And to understand what this means, we need to know two words: scarcity and rivalry. If something is scarce, that means it is of limited or finite amount. And if something is rivalrous, that means one person's consumption of it necessarily prevents another person's consumption of it. So let's kind of look at how these concepts interact with physical things versus ideas. Physical things are tangible. You can hold them in your hands. They cannot just pop into existence out of nowhere, and you can pluck them from grass. So we say that physical things are both rivalrous. And because of this, it is easy or straightforward to extract value from them. I'm not going to give it to you until you pay me. Ideas, you cannot hold in your hands instance without raw materials from out of nowhere, and you cannot pluck them out of somebody's grasp. So we say that ideas are neither scarce nor rivalrous. Because of this, it is difficult to extract economic value from an idea. So to kind of clarify this, I have two brief examples. Let's say that there's one apple. That apple cannot be in both Bob's stomach and Sally's stomach at the same time. It's in one stomach or the other, not both. Now, what happens when we introduce some economics into this? Let's say that Sally wants to buy Bob's apple. Before she does, she wants to inspect it to see if it's rotten. Nobody wants to buy a rotten apple. Notice that the act of inspection does not give Sally the ability to eat the apple. If she wants to eat it, she has to pay for it. Now let's change this up a little bit. Let's say instead of an apple, there's a design for an apple crate. So maybe instead of using nails to put your apple crate together, you're using some sort of wooden joinery. This design, this idea, can be both in Bob's mind or brain and Sally's mind or brain at the same time. So how does this change when we introduce economics? Well, if Sally wants to buy Bob's crate design, first she wants to inspect it to see if it's worth the price. But here, unlike with the apple, the act of inspection gives her all of the details. She now knows the design. It's in her brain now. So what's stopping her from not paying Bob and just going to use it anyway? The answer is IP law. That's what stops her. IP law provides artificial scarcity and rivalry to ideas so that we can economically treat them as if they are physical property. And this provides an incentive to innovate, an incentive to come up with new ideas. After all, if somebody could just take your idea with impunity, why would they expend all the effort to create the idea in the first place? So there are four main types of IP. You have copyright, trademark, trade secret, and patent. Now, in this presentation, I'm going to address each of these in turn. The first three will be somewhat brief, and we'll spend most of our time on the patent aspect. So let's start with copyright. Copyright protects artistic expression. So this is paintings, or drawings, or sculptures, music, movies, even characters like Steamboat Willie or SpongeBob SquarePants. An important limitation of copyright is that it does not protect the underlying concept. It only protects the expression itself. So to clarify this, the Steamboat Willie copyright prohibited people from drawing mice that looked too much like Steamboat Willie. It did not prohibit all possible depictions of mice who were driving steamboats. In order for a copyright to be valid, it has to be fixed in a tangible medium. So this is pretty straightforward. The medium could be physical, like paper, stone, metal, even ice. Ice sculptures are copyrightable. Or it could be electronic, like DVDs or audio-video files. The important thing is the work itself cannot be fleeting. It can't be an unrecorded performance. And in order for your copyright to be valid, it has to involve what's called a modicum of creativity. In other words, it has to be at least a little bit creative. It cannot be purely banal. This is a very low bar, very easy to satisfy. The only case I'm aware of where this has not been satisfied was where somebody tried to claim copyright protection for an alphabetized phone book. The court said listing names and phone numbers in alphabetical order was not creative. But most of the time, if you do anything artistic, creativity is involved. Copyright law does not involve an examination process. In other words, the Copyright Office does not judge the value of your work. You just go to the office, you register your work with them, it's quick, it's inexpensive. Now, let's say that you have a copyright and you sue somebody for infringement. To win, you have to satisfy what's called the overall look and feel test. This is just a fancy name for comparing the visual and audible characteristics of your work with the allegedly infringing work. Now, in response, that accused infringer might say, well, hold on, there is no infringement because this was a fair use. This is a defense that they can assert. Now, fair use depends on two things: the extent of the copying and the purpose. So, did you copy the entire book? That doesn't sound very fair. Or did you just copy like a little excerpt, a quote? That sounds fair. What about the purpose? Was this for parody or satire or education? Those are all fair use. Instead, was it for commerce? Were you trying to make money or profit off of it? No, not fair use anymore. And one more defense to be aware of is the independent creation defense. So copyright prohibits copying. Now, what happens if somebody comes up with a piece of art that looks like yours, but they didn't actually copy yours? Maybe they never knew yours existed, they never had access to yours. This is a hard defense to prove, but it's powerful if you do prove it. Copyright only prohibits copying, not independent creation. And the last point about copyright law is the duration. It has pretty long-term protection. Normally, it lasts through the entire life of the author and 70 years after that. So quite a long time, which is why Steamboat Willie, his copyright, I believe, just ended last year, even though he was made in the early 1900s. So quite a long time. But that is a high-level view of copyright law. On we march to trademark. So trademarks are source identifying marks. In other words, they protect brand names. Now you have two types of marks out there. There are word marks. So for example, McDonald's or Disney. But you also have something called an image mark where it doesn't have any words. So a good example of this would be McDonald's golden arches, or maybe the Disney castle silhouette. Those are image marks, not word marks. In order for a trademark to be valid, you must be using it in commerce. That means you have to be using it to sell some good or service. You are not allowed to just sit on it idly. And the most important requirement for a trademark to be valid is that it must be distinctive. It cannot be just a descriptive word. Now, there are a couple of different examples of distinctive. It could be fanciful, just a made-up word like Exxon. Or it could be arbitrary. It could be a real word that has no relationship to the underlying good or service. So Apple for computers. Or it could be a suggestive mark. It might be a real or not real word, and it kind of hints at what the good or service is. So a good example is Microsoft for computers, right? Microchips, software, Microsoft. It hints at what the good is. Those are all distinctive. But the important thing is it cannot just be a mere description of your product, because otherwise you would be stopping other people from truthfully describing their goods, and that's not permissible. So a good example is, if I were a glove salesman, could I trademark the term leather gloves? Probably not, because then I would be preventing other people from describing their leather gloves. Now, there is an important exception to this rule. It's called the secondary meaning exception. It's rare, but it's powerful if it happens. This is when you have a mark which at first glance is just a descriptive term, but it has become so established that the consumers, the people in the public, automatically associate it with a particular source. So the best example is International Business Machines, IBM. Other companies are surely able to sell internationally machines that are used in business. But when you hear International Business Machines, everybody knows exactly what company we're talking about. Trademark law involves a moderate examination process. So the trademark office will judge the distinctiveness of your mark. This is mainly done by comparing it to other marks in their database. And let's say you have a valid trademark. If you sue somebody for infringement, you need to satisfy what's called the likelihood of confusion test. That means you need to show that consumers are mistakenly thinking that the accused person's products are coming from you. Normally, you do this by comparing the appearances of the marks, the sounds of the marks, the pronunciations, and of course, the fields of goods or services. Sometimes you can even get like empirical surveys or focus groups done and actually ask customers, hey, here's a product. Who do you think made this? And use that as evidence. As just a quick example, Toyota. Everybody knows Toyota is an auto manufacturer. Let's say that I create a company called Moyota. Am I violating their trademark? Well, very similar pronunciation, very similar spelling, so it would probably come down to the fields of goods or services. If I'm also in the auto industry, I'm probably infringing. But if I'm in the honey-baked ham industry, probably not infringing because no one's going to think that Toyota all of a sudden broke into the honey-baked ham market. Just like with copyright law, we have the fair use defense. So are they using a mark that looks like yours for satire or parody? That's okay. Are they instead trying to make money? Not okay. There's a little bit of a wrinkle in trademark law. You have what's called trademark dilution. So even if there is no likelihood of confusion, or even if it is fair use, you, the trademark holder, have one additional chance to get the infringer with this trademark dilution claim. It's hard to prove, but you're essentially trying to say that their mark, even though it's not infringing, has somehow tarnished the reputation or uniqueness of your mark. Very hard to prove, but it is something to be aware of, just another cause of action that's out there.
Hey, Cameron.
And, oh, please.
We have a chat question.
Sure.
If I apply for a trademark, should I show it on a product with the quote unquote registered mark already, or just how I created it?
Yeah, like you're talking about the circled R. The circled R means it's already been registered, so you would wait for that. However, it is important, like I said, you have to be using your mark in order to get the trademark in the first place, right? In order to register it with the trademark office. So yeah, you would want to be using it on your product. Use it on the packaging, or use it on your online web page where they can buy the product. So yeah, but with respect to the circled R, I would probably wait until it's actually granted by the trademark office.
All right. Thank you. Did that answer your question, Keelan? I hope I'm pronouncing your name correctly. Okay, he said thanks. He or she.
Yeah, absolutely. My pleasure. Please, more questions, the better. The last part I want to talk about for trademark law is the duration. So trademark law can last potentially forever. It lasts as long as you're using your mark and that it remains distinctive. Now, to protect the distinctiveness, this will often require active effort on your part. So sometimes you need to send cease and desist letters out to people who are using marks that are too similar. Sometimes you need to engage in infringement lawsuits against these people. But sometimes you can engage in other types of strategic brand management or public outreach programs that teach about what your mark means and the products that you make. Anything like that helps protect its distinctiveness. But the interesting thing here is, if you ever lose your distinctiveness, this is called genericide, right? This happens when your mark has become so popular that people are now using it as just the general product description rather than a source identifier. So some real quick examples. If you have to sneeze, do you grab a Kleenex or do you grab a tissue? What about if you scrape your knee? Do you grab a Band-Aid or do you grab a bandage? So these are things like that. Very important to do your best to protect the distinctiveness of your mark. That is trademark law. So now we go to trade secrecy. So trade secrets protect confidential information. That is, any secret information that gives a company a competitive advantage and that the company has taken reasonable efforts to keep secrets. There is no examination process, nor is there a registration process for trade secrecy law. All you have to do is actively keep it a secret. So use a vault, use a physical vault that houses your secret. Or if it's electronic, make sure you're using encryption and password protection. If somebody can physically access it, make sure you keep detailed access logs that says who accessed it at what time. If you're dealing with third parties, make sure they're signing non-disclosure agreements. You have to actively keep this thing a secret. Now, if you have a trade secret, it gives you the right to sue somebody for misappropriation or theft of that trade secret. So here's a little example. I don't know how familiar everybody is with SpongeBob SquarePants, but one of my favorite television shows growing up. If Plankton were to steal the Krabby Patty secret formula by breaking into the Patty Vault, Mr. Krabs could sue him not just for trespassing into the vault, but for the commercial value of the stolen secret. So that's the power of trade secrecy. However, what happens if Plankton just came up with it on his own? He independently created the formula and he didn't actually steal it. Well, in that case, you do not have any recourse. Just like with copyright, trade secrecy has the independent creation defense. And lastly, the duration. Trade secrecy can last potentially forever. As long as you keep it a secret, you got the protection. A great example of this is Coca-Cola. They have their trade secret cola recipe is, I believe, 140 years old, something like that, and counting. So it can last quite a long time. And now we get into the meat and potatoes, my favorite area, patent law. So patents protect inventions. In other words, they protect useful things. You can think of a patent as the flip side of trade secrecy. So trade secrecy allows you to profit from something by keeping it to yourself. On the other hand, patents allow you to profit from something by disclosing it to the public in the form of the patent application, right? So keep it to yourself as trade secrecy, disclose it to the public, patent application. If you get an issued patent, a valid patent, it gives you the right to exclude others from making, using, selling, offering to sell, or importing your invention. So you get to stop others from using your invention. It's a pretty powerful right. However, there is an interesting technicality here. Patent law does not give you the affirmative right to practice your invention. Usually you'll be able to practice it, but not always, because maybe your invention builds off of somebody else's patented technology. So in which case, their patent might stop you. Or maybe there's some sort of national security law or international trade law or something that would prevent you from importing the parts for your invention, something like that. So it's a right to exclude others. That's what a patent gives you. Unlike copyright and trade secrecy law, there is no independent creation defense in patent law. So it's a little bit stronger here, right? If you have a patent on an invention and it's valid, you can stop anybody else from using it if you want to, even if they didn't take the idea from you, even if they came up with it all on their own. Unlike trademark law, there is no use in commerce requirements. So you don't have to actually be selling your product or using it or anything like that. You can patent it and sit on it if you wanted to. So a lot of people actually are not fans of this particular thing because it gives rise to what are called patent assertion entities, otherwise non-lovingly referred to as patent trolls. These are basically companies that they don't really make or sell anything. They're just in the business of buying patents and then trying to sue other people for infringing those patents. But for better or
Quick
worse,
question.
there is
Sorry.
no use. Go ahead, please.
Would a food recipe pass as a patent?
So that is interesting. That's something I would probably have to look into a bit more closely because we don't get a lot of food related things. Normally it would be like a food preparation device. I suppose cooking a meal would qualify as a process, which we'll get into, which is a patentable thing. The important thing is that it has to be useful and ideally better than what's already out there. So
I was thinking of like KFC. Is that more trademark?
yeah, so the name KFC, that's a trademark. how they
And then their
package their
secret
food.
sauce. Yeah.
Yeah, if they came up with a really cool way of packaging their food to the consumer, really cool, never before seen cardboard box that holds the chicken wings in a better way, the box might be patentable. Probably the way of cooking the chicken itself, it depends. That's a very unique question. So I'm sorry if I'm not able to give a more direct answer. It's something I'd probably have to do a little bit of research on.
Yeah, I think we're getting into now like trade secrets. Is that what we would consider a trade secret?
Exactly. Yeah. So
But
anything.
probably not your department.
Yes.
Yeah.
No, 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 no worries. So like that's another great point. So anything, if you have a competitive idea and you consult with a patent attorney and they think that it might not qualify for patent law, which we'll get into all those requirements later, you can always keep it as a trade secret. Absolutely. There is no limitation. The only limitation on what can count as a trade secret is it has to be kept secret. It can't be something that is widely known or that is easily knowable just by looking at your product. It would have to be some secret thing. So if you come up with some awesome chicken recipe, that would be, yeah, just like the cola recipe for Coca-Cola, that would be an awesome trade secret to have. Does that make sense?
Yeah. Thank you.
Okay. So moving on our patent journey, unlike all of the other areas of IP, patent law involves an extremely rigorous examination process. Because the rights are so strong, we need to make sure that we're not issuing bad patents. That's the idea or the hope. So this means that the patent office will closely scrutinize your invention. This typically takes the form of years, 2 or maybe 3 years, maybe longer, depending on how complex the invention is and how much prior art there is. Years of back and forth with the patent office and arguing with them. And it can get quite expensive. We're talking thousands of dollars in filing fees, examination fees, issuance fees, and tens of thousands of dollars in the post-grant maintenance fees. Now, fortunately, the patent office does give discounts. They give a 50% discount for small entities, and that's any company who has less than 500 employees, well, fewer than 500 employees, and who has not, they don't have an obligation to sell their invention to a company with more than 500 employees. So you do get a pretty substantial discount from the patent office, which is good. Additionally, because it gets so expensive, it's not just a US thing, it's expensive pretty much in any country you go to. So because of that, pursuing patent protection in multiple jurisdictions at once, in the US and Canada and China and the UK, that's pretty much cost prohibitive for all but the largest companies in the world. And finally, we have the duration of patent law. Because the rights are so strong for patent law, Congress has tried to temper this, balance it out by giving it the shortest term. You have 20 years from date of filing. That is it. You don't have life of the inventor plus 70 like copyright law. You don't have potentially eternal protection like trade secrecy and trademark. You get 20 years from your filing date and nothing more. So what are the different types of patents? Well, there are three main types. There's the plant patent. This, as its name suggests, protects new types of artificially engineered plants. This is really not a big practice area. Then there is the design patent. So this protects unique ornamental designs or visual appearances of a manufactured thing, of a manufactured product. So an example might be the aesthetic swooping shape of a car hood. This is also not a very big practice area. But I saved the best for last, utility patents. This is the big practice area. The utility patent protects any process, machine, manufactured article or thing, or composition of matter, so chemical formula. So this is 99 times out of 100, when somebody mentions patents, they're talking about utility patents. And this is the one we're going to focus on for the rest of our discussion today. So there are two types of utility patent applications. You have the non-provisional and you have the provisional. The non-provisional is your normal or standard patent application. This is examined by the patent office to ensure that the patentability requirements are met. This can mature into an issued patent. This can get the benefit of earlier applications. You can get an earlier filing date if you satisfy some special rules. It's the normal patent application. The provisional patent, on the other hand, is a special tool that's available to you. You would file a provisional application if you're in a rush, if you have your invention ready and you're using it, or you want to use it, but you don't have the time to get a full non-provisional application ready. You don't have time to cross your T's and dot your I's. So a provisional patent application is a quick and dirty way to get an early filing date. It's a way to buy time. So essentially you file this and then you have 1 year thereafter to get your proper full non-provisional filed at the patent office. Provisional application never matures into an issued patent. It is not examined by the patent office. It cannot claim priority to earlier applications. It is just a quick and dirty way to buy time. So the normal patent application is the non-provisional. So what are the parts of a non-provisional? This is where I come in, patent attorneys like me. We draft the non-provisional, we create it, and we do our best to make sure that they are thorough, robust, comprehensive, so that they can withstand the scrutiny that they will be subjected to at the patent office. Now, a non-provisional has 3 main pieces. The first is the specification, or spec, we sometimes call it. This is the detailed prose that explains all the ins and outs of your invention. So just normal language, paragraphs upon paragraphs. It might be 5 pages, it might be 80 pages. It's anywhere in between. You're just explaining the details of your invention in normal prose writing. The second part is called the figures. This is actually my favorite part to draft because I love drawing the flow diagrams and block diagrams and so on. But these are basically the illustrations, the drawings, the schematics, the flow charts that pictorially show the different pieces, the nuts and bolts of your invention, or how your invention can be used. And lastly, we have the claims. So the claims are the verbiage that delineates what we call the quote unquote metes and bounds of the invention. That's a really archaic phrase, but basically the claims specify exactly that which you are trying to protect. So a good metaphor for this is claims are to your invention what a fence is to your yard. It runs around the boundary. It defines or delineates the outer perimeter of the thing you're trying to protect. In practice, they end up looking like very ugly run-on sentences, and they have to follow a lot of strange non-prose rules, very hard to read. But essentially, these are the 3 things that it's my job to draft, and we do our best to make sure that they are comprehensive and that they can withstand a judgment by the patent office. So talking about that judgment, what does that involve? Well, there are several patentability requirements that you have to satisfy. And they are as follows: inventorship, utility, adequacy of disclosure, novelty, non-obviousness, and eligibility. So we are going to address each of these in turn, and I hope nobody's eyes are glazing over. I'll do my best to make this as fun and interesting as I can. So the first requirement is inventorship. All this means is we have to list the inventor's names on the patent application. That's it. This is very easy to get right, but it's very important to get right, because if we're wrong, we risk totally invalidating the patent application. So in other words, if we fail to list somebody who truly is an inventor, or if we listed somebody who is not a true inventor, then we could be in trouble. So what is an inventor? How do we define an inventor? Well, there are 2 things. The first thing has to be a human, cannot be AI. This really has never been an issue before. This only has come up just recently with the recent explosion in Gen AI and ChatGPT and all of that. But the courts have been very clear. An AI model by itself cannot be an inventor. A human has to be an inventor. A human can use an AI tool when they're making an invention, that's okay, but something that is produced solely by AI with no input whatsoever from the human, that by itself would not qualify as an invention because it has no inventor. So it's got to be a human, got to be a person. The second thing, and this is the important one, is that an inventor is somebody who contributes any amount of conception to the claimed invention. That's the legal language, any amount of conception. What does that mean? It means it's a person who devised or thought of or came up with the claimed invention, any part of the claimed invention. This is not somebody who merely physically built the invention or who merely tested the invention. So you can kind of think about this in terms of brain work versus leg work. Inventorship is all about brain work, not leg work. So a good example, real quick for this, let's say that we have three people, A, B, and C, and they collaborate with each other on a neural network project. So let's say that A and B come up with a specific neural network architecture that learns faster than existing architectures are able to learn. And let's say that B actually programs a real world version of this neural network. And C helps B do so by collecting training data and performing tests and otherwise following B's instructions. In this example, A and B are the inventors, C is not. Why? Well, because A and B did the brain work, B and C did the leg work. So B did both brain work and leg work. Because he did brain work, he's an inventor. A did only brain work, but that's what we care about, so he's an inventor. C did only leg work, not an inventor. So I hope that kind of helps to clear it up. And the last portion of inventorship is that all joint inventors are equal. So many applications in this day and age will involve multiple inventors. Each one is called a joint inventor, and they are completely equal, co-equal in the eyes of the law, no matter their respective amounts of contribution, no matter the respective amounts of work that they did on the invention. So this is not like a science publication where the lead author gets more credit or more glory. No. Somebody who conceives of just 1% of the invention, they are 100% an inventor, totally equal. But that's inventorship. So then we move on to the next requirement, which is utility. So the statutory section that defines utility, I have it up there, Title 35, United States Code Section 101. This is very simple. It just tells us the invention has to be useful. It has to be good for something. This is an incredibly low bar to satisfy, very easy. This is only ever an issue when the invention is believed to be impossible. So maybe the very first flying machine would have gotten a utility rejection, or if somebody tries to patent a perpetual motion machine, right, that would violate the laws of thermodynamics. So that's impossible. So that I would probably get a utility rejection. But most of the times, this is a non-issue. Next, we get to disclosure. So again, this is what I, as a patent attorney, have the most control over. And so, my job is helping to make sure that we satisfy these things in an ironclad fashion. So the section that defines disclosure is Section 112. And this just defines for us how much detail we need to include in our application. How many tidbits about the invention do we have to show in the figures and in the spec and all of that stuff. Now, there are actually several subparts to this. I'm going to kind of break it down one by one. The first part is enablement. The legal language is a whole mouthful. And the legal language is you have to provide enough detail so that you teach a person of ordinary skill in whatever field this is to make and use the invention without undue experimentation. Like I said, a mouthful of legalese. What does that mean? It means that we need to make sure we elaborate on the new stuff. We don't need to encyclopedically describe things that are already known. But if we rely on anything that's already known, we should still mention it. We can mention it. We don't need to encyclopedically, beat a dead horse and describe with great detail what's already out there. Just mention it if we need it. But most of our effort is spent on describing what is the new piece of your invention. The second subpart of this is called the written description requirements. So again, the legalese here is that we need to provide enough detail to show that person of ordinary skill that the inventor was, quote unquote, in possession of the claimed invention at the time of filing. What does that mean? This is a rather odd requirement. Normally, it rises and falls with enablement, but the purpose of it is to address a loophole where something might be enabled because it's relying on a piece of background information that the person of ordinary skill knows. So it's enabled, they know how to do it, but you didn't mention it. You didn't describe it at all. You didn't even name it, right? So we need to make sure, again, it's just telling us, make sure we're thorough when we're describing our application. The next part of this is called definiteness. This is pretty simple. This one tells us that any terms we use in our application, in the figures, in the spec, and the claims, must have concrete, understood, or well-defined meanings, definitions. We can make our own definitions if we want to. We can totally do that, not a problem at all. We just need to make sure we use clear language, clear definitions, and we stay away from vague or ambiguous language. So a real quick example of this. If I said A is close to B, the patent office would say that's indefinite. It makes sense to us. A is close to B. Is either close or not close. But the patent office will say, well, what constitutes close? Is it 10 feet? Is it 1 foot? Is it 5 inches? What's close? So to rephrase that, you could instead say A is within a threshold distance of B. So again, this is what we lawyers do. We make everything much more complicated than it needs to be. But the patent office would like this. They would say that this rephrasing is definite because, well, now there's a threshold distance involved. And it makes it a binary comparison. We're either less than the threshold distance or we're not. So that makes it definite. The next portion of this is called best mode. This one, generally not an issue and very simple. If you have a particular way of practicing your invention that you know is super awesome or really, really good, you need to disclose that somewhere in the application. You're not allowed to keep the best part of the invention for yourself. That's all this means. Interestingly, though, you don't have to call out or emphasize what the best mode is. I don't need to say, hey, the best mode is XYZ. I can just say, hey, in some cases, we can do XYZ. So that if you want to be a little strategic about it, that's one way to do it, to include the best mode without calling it the best mode. And finally, no new matter. So when we are arguing with the patent office, we go back and forth, we will have the opportunity to make amendments to the patent application, right? Amend the spec, amend the figures, amend the claims if we need to, and rephrase things, just like that example I gave you, to try to address the rejections that the patent office gives us. An important restriction here is that every amendment must be substantively supported by the original application. You cannot add new things. You can rephrase things. It doesn't have to be a verbatim copy and paste, but the substance has to be there. You're never, ever allowed to add something new, some new substance or new topic that was not previously discussed. You're never allowed to add that. So again, it's very important for us to be as thorough and comprehensive as possible at the drafting stage. But that is disclosure. So we march on to novelty. So novelty is defined by section 102.
Sorry,
and this tells us that the invention.
I feel so bad every time I interrupt. I just want to give you kind of a five, if you could, 5 more minutes, and then I was going to open the floor to questions because I know that people have them. So
sure.
Again.
No problem at all. I'm sorry if I'm taking too long or dragging my feet. So let us blaze through these last few slides I have for you guys. So novelty, non-obviousness, and eligibility. Those are what we have left, and those have become the really important ones. Novelty just says that the invention has to be new. In other words, it cannot already have been patented. It cannot already have been published somewhere. It cannot already have been sold somewhere. And we judge this with what's called the effective filing date of your invention. So this is the date that you actually file at the patent office, or like I mentioned, you could buy time. So it's your earlier date that you're entitled to. But the important thing is that the earlier your date is, the better, because prior art can only be cited if it occurred before your effective filing date. So now here's an important question. What happens if you make a sale before you get a patent on file at the patent office? Well, that can absolutely be prior art against you. So the important thing, but the important thing is try to get the patent office, try to get to the patent office first. However, we have luckily what's called the grace period in the US, the 1 year grace period. Basically something that occurs less than 1 year before your filing date. So maybe you sold your invention. It is not prior arts as long as that thing was made by the inventor or somebody who got it from the inventor. So if you sell your invention before you get to the patent office, you have 1 year to get your patent application filed. Importantly, though, this is only for the US. Most foreign countries do not have that, so just be very careful. And the last part of novelty is that, what does it look like in practice? The patent office will try to find a single reference, one patent, one published science paper, one something that teaches all the elements of your claim. And what you want to do is try to point out at least one element that is not in that reference. We go to non-obviousness. So section 103 is what defines this. This tells us that the invention, it's not enough to be new. We have to be more than new. We have to be clever. We have to be counterintuitive. There has to be something unexpected, unusual, or creative about our invention. A good way to think about this is that novelty is about showing that others did not do your invention, and non-obviousness is about explaining why others would not have done your invention. Did not versus would not, and you need both. What does it look like in practice? So with novelty, there was just one reference. Here, you have multiple references. The patent office will try to find two or more, and they will say that the person of ordinary skill would have been motivated to combine those two or more references together. And your job to win is to say, well, hold on now, you're still missing one claim element. It's not in any of these references. Or you have to have a persuasive explanation for why those references would not have been combined. And that's where our cleverness and counterintuitiveness comes into play. And lastly, circumstantial evidence. So this is not usually present, but if it is, it can be very helpful. Circumstantial evidence of non-obviousness would be like, if the industry that you're in praised your invention when you released it, or if they all started copying you when you released it, or if they had failed for years to solve the problem and then you came and you solved it, something like that. That's a great piece of evidence to include in your patent application if you have it. All right, but that is non-obviousness. And we get to the last patentability requirement, which is eligibility. So this is defined by section 101. And so really, this has become a legal quagmire in recent years. This used to be an incredibly low bar, very easy to satisfy. Everything under the sun made by a man was eligible to be patented. Unfortunately, that is not the case anymore. The courts have overcorrected in response to some extremely broad patents people were seeking. And so now eligibility has become a very murky issue, especially for software and medical diagnostic inventions. However, fret not, because there is still a way forward. And that is this. We need to show that our invention is a technical solution to a technical problem. So in other words, there should be some task that you want to do. Existing ways of doing that task suffer from certain technical disadvantages. They consume too much latency. They have too little accuracy. And your invention cleverly accomplishes that same task, but without those disadvantages. You've measured the latency and you have 20% less latency, or you have 30% more accuracy. If you have experimental results showing that, that's perfect, all the better. But this is probably the biggest takeaway from today's discussion. If you've learned nothing else, at least know if you want to get something patented, please prepare a narrative that casts your invention as a clever technical solution to a vexing technical problem. So real quick, Chandler, I apologize if I'm going to go a few minutes over. I'm almost done.
You're fine.
Real quick, I have a couple of common pitfalls to make sure that we're careful of with respect to eligibility. So I say beware of business, beware of mere automation, and beware of mere results. So business. Chandler and I were actually just discussing this a little bit today. When you make a startup, when you're trying to get capital, right? Build capital, get investors. You want a good business plan. You want to talk about finances. You want to talk about business strategy. But you need to flip a switch when you're looking at patents because the patent office does not want to see business stuff. The courts do not like business things in patents. They don't want to see customer experiences. They don't want to see investment strategies. They don't want to see bank transfer settlements. They want to see technical things. You increase the accuracy of your model. You reduce the amount of slag that your manufacturing process creates. Something technical, not businessy. Mere automation. So some people try to get around that business thing by having business patents, business subject matter, but that they were implementing on a computer. And they would say, okay, instead of having the cashier or the clerk write down and all the timestamps for our transactions or the account numbers, let's have the computer do it. And the computer does it faster. It's 30% faster and it takes 50% less time. That's a technical benefit, right? The court said, no, not so fast. You're trying to game the system because there's nothing clever about that. That is precisely what computers do. If the only difference between your invention and the prior art is that the prior art does steps A, B, and C manually, and you told the computer to do steps A, B, and C, not enough. It might be enough if there was some reason why the computer could not do it previously. It was impossible for the computer to do this previously. And you came up with a specific technical tweak that lets the computer do it. Now that's eligible. But if all you're doing is telling the computer to do what the cashier was doing previously, not enough. And lastly, mere results. A claim that tries to cover every possible way of solving a problem is not eligible. You have to claim the specific solution that you came up with to the problem, not every possible solution that there could ever be. So that handles it for our patentability requirements. And my very last slide, these were just a couple of quick tips, miscellaneous tips that didn't really fit into the other portions of our slide deck today. First one is duty of candor. Just if you're trying to get a patent application, you have to be truthful when you're dealing with the patent office. And part of that truth means you don't hide prior art that you are aware of. There's no duty to go looking for prior art. But if you are aware of a specific research paper that's been published that is really on point, or a specific product out there that's really on point, you got to tell me, your patent attorney, or tell the patent office directly. Just let them know that it's there. Patentability versus freedom to operate. I bring this up because we've had some clients in the past where they wanted to get a patent, and so they were trying to do their own prior art search, and all they were looking at were the claims of other issued patents. That's useful, but remember what we said, it's anything in the public, anything that's been published can be cited as prior art against you. So if you care about patenting your own invention, you don't just look at the claims of other patents, you look at anything that's been published. On the other hand, if you don't care about getting a patent, if all you want to do is know if you are allowed to practice something or sell something or make something, that's called freedom to operate. And in that case, all you care about is claims of issued patents. And lastly, patents versus profitability. I bring this up because not all patent ideas or not all profitable ideas are patentable. Not all patentable ideas are profitable. You can think of them as a Venn diagram. They are not mutually exclusive, but they're also not coextensive. So I just bring this up because don't be discouraged if you have an idea that you're really excited about and a patent attorney says, well, it's probably not eligible or it's considered obvious, because you might still make a lot of money doing it. Again, good for business does not mean it's good for the patent law. And on the flip side, don't be overconfident. If you release a product and it makes oodles of cash for you, awesome, but that does not mean it's patentable. All right, but that is it for my presentation today. So I hope I did not lull anybody to sleep, and I think we have a couple of minutes for any questions you might have.
Actually, Kenya, I know you have to leave, and I hope I didn't mispronounce your name. If you want to go real quick before you have to hop off.
Oh, I thought you were going to ask the question for me.
Oh, I'm sorry. I just called you out.
Yeah, you did. Yeah, so I was wondering about a hairstyle, the end result. Like, would that be a copyright or a patent?
So like a hairdo or a hairstyle,
Yes.
probably not the realm of patent law. So that would probably be something like copyright. But again, it has to be fixed. So somebody's hairdo by itself probably wouldn't be considered fixed enough. It might be considered transient because the hair will, throughout the day, the hairdo will come undone, something like that. But a picture of the hairdo, that would be copyrightable, or a sculpture that depicts the hairdo would be copyrightable, something fixed in a tangible medium like that. Does that make sense?
Yes, and if I may, you
Mhm.
spoke on, I hope I'm saying this right, non-obviousness patent. And
Mhm.
so that kind of like rung a bell. It changed, the hairstyle changed the industry. Everyone started to copy it.
Gotcha, gotcha. No, I'm glad. So that's awesome that you're trying to apply those tips. So that's perfect. Um, Again, the problem is, so with that it almost kind of reminds me of the food thing that Chandler asked about earlier. I would probably have to do a little bit of research on it because I've never come across a hairdo patent myself. Again, if you come up with a new type of hair dryer, or a new maybe like a new type of device that helps you make the hairdo that no one else has ever done before, that device would be patentable. The hairdo itself, even though it's wonderful and it's profitable, again, if everybody's copying you and they love it and you're making money off of it, that's great. But like I said at the end, profitability does not equal patentability. I wish it were. I wish patentability were a little bit broader, but sometimes it can be a little rigid. Does that answer your question?
Yes.
Thanks, Kenya. Okay, Ralph, you want to answer your question? I'm going to call you out next.
Okay. Thank you for the seminar. First of all, this was very informative. I'm looking at AI and I'm wondering to myself, if I create a method of doing something using AI that produces something of value and is actually could even be branded, what am I going to do here? Is this a patent? Is this a copyright? What's the
Yeah,
ability to get protection for it?
Yeah, it's a great question. So I have to preface everything by saying the devil is in the details. It would depend on the specific facts of your case. So I'm a lawyer, so I'm not allowed to. I'm obligated to not tie myself down. I got to leave all options open. But it just depends. So AI right now is exploding everywhere, and the law, it's a new thing in the law. People using AI, there are lots and lots and lots of people trying to patent different ways of using AI, and sometimes the courts like it, other times the courts don't. It'll depend on, if you remember what we talked about with eligibility, it depends on, are we using AI to just automate the specific steps that somebody else was doing manually? If that's how your invention can be framed, the patent office probably wouldn't like it. On the other hand, if the AI is doing something, you're doing some specific thing that hasn't been done manually before, you might be able to protect it. And the output itself, so it depends on what the output is. You said if the output might be branded, is it an image? It could be copyrightable. Is it some
It's
sort of,
text.
it's text? Again, text absolutely could be copyrightable. You do want to be careful with, is it the AI creating the text all by itself, or are you using it somehow? As long as there's a human user, you would be considered the author of the text, and you would be able to copyright that text. If the AI is doing it all on its own, you kind of might run into the same issue where an inventor has to be a human and an author also has to be a human. So you want to make sure you're doing something, you're feeding something to the AI, so that its output is attributed to you and not just to the AI. Does that make sense?
It doesn't. Final question. I understand, and I just want confirmation that you may not copyright a fact.
Correct. So copyright does not apply to the underlying concept, right? It only protects expression of a concept, not the concept itself. So yeah, there is, if I make a painting of SpongeBob SquarePants or something, nobody else can make a painting that looks too much like that. But that doesn't prohibit all depictions of SpongeBob SquarePants, right? So a fact, copyright would only protect the specific text, the specific way that you're telling the story to convey that fact, not the fact itself. Does that make sense?
A news story that I committed murder. The fact
Hold on, Ralph. Hold on. Does anyone else have a
murder,
question
well,
before Ralph goes there?
if you that's the fact of the story. It's
Right.
the way you write it up that's copyrightable.
Correct. Correct.
Other newspaper could come back and report the very same fact.
Exactly. Exactly. Yes.
Okay. So
Okay.
that's my question. I got it.
Good. Does anyone else have a question? We're at 1:02 now. So just want to make sure before I have to let Cameron get back to his day job.
Thank you.
This is Keelan. I have a question.
Yeah, go ahead.
I probably should say it afterwards, but or ask him personally to become my patent attorney. I have a couple of different things that I'm working on. I have been working on for years, but most recently I had to create a
real quick. Make sure you don't publish anything. Don't give any details here. Just keep it high level.
And that's why I said maybe I should ask you off of the video. But without giving any details, one thing that I want to create actually has two different, and I think you spoke of this, two different already patented things, but that I would be using, but I'm creating something different, merging the two. You know what I mean? So would that be something that I can actually patent, being that there's already two other companies?
Yeah, no, so a great question. So again, when it comes to, that sounds like the non-obviousness stuff we were talking about. You can absolutely use the building blocks that came before you. I mean, that's how innovation works, right? We use the pieces that other people have made to make new things. That's exactly what innovation is. So there's nothing wrong with that. If they already have patents that are still in force and you were to get a patent on your invention, remember, you would not necessarily have the right to actually practice your invention because their patents, to practice it, you would have to be using their patent, so you need their permission for it, right?
Gotcha.
So that is something to keep in mind. The other thing to keep in mind is at the patent office, the patent office would say, hey, here's patent A, here's patent B. If I combine them, I get your invention. And you need to make sure that you have something and you say, no, you're missing part C, or fine, you get my invention, but nobody would have combined them because here's my clever little explanation why nobody would have done it. Here's the counterintuitive tidbit, right? So that's always the important thing to have when it comes to patent law. Does that make sense?
Makes perfect sense. Makes perfect sense. So second part of that question, you have a half hour after this that I can talk to you.
You guys can send any questions to me. And Cameron, go ahead.
Please,
Sorry,
if you guys seriously. No, absolutely. If so, I don't have. I do have to get back to my day job. Hopefully not fired yet. But yeah, if you have any questions, feel free to send them to Chandler. She can forward them to me. Chandler, if you want to give my email to anybody, that's perfectly fine too.
Okay, as long as you're okay with that.
Yeah, no, anything we talk about, I have to just be very clear. So just talking about it with me does not create an attorney-client relationship. That would not ever happen unless we had like an actual engagement letter. But anything we talk about would still be confidential. The rules of ethics prohibit me from sharing any details. You guys, if you have questions, anything like that. So don't think that I'm going to go onto the black market and start making lots of money on your ideas or anything.
I just need to know that it's worth it.
All right. Absolutely. Anybody else? Great. So again, we are going to put this online at ybi.org/evolve under our Lunch and Learn series. Please feel free to email Rory or me with any questions, and we will direct them to Camron. And Camron, I cannot thank you enough. This was extremely informative, and we really appreciate your time.
Oh, my pleasure, Chandler. Absolutely. And I hope everybody enjoyed it. I know I was practicing this with my wife a little bit. She was like, "Boy, I hope these people stay awake." So I hope
We
I hope I
did.
made it. I hope I made it interesting enough for you.
Yep, it was great. Thank you. I really appreciate it. And everybody have a great day. We are going to be putting these on once a month, different topic every time. So follow me or Rory or just YBI Evolve on LinkedIn so you can know what we're doing. And Camron, thanks again.